Hello friends, are you going through a divorce case in which your spouse is going to be on the hook for either child support or alimony, and all of a sudden he is going through what a very famous and beloved judge here in Miami-Dade County used to call RAIDS, recently acquired income deficiency syndrome, meaning they don't make the money they used to make? Well, we've got you covered. Today we're going to talk about underemployment, when a spouse purposely makes less money than what they used to make. Welcome back to the Divorce Broadcast. My name is Manny Segarra, coming to you from Miami, Florida. So, what is underemployment? Well, underemployment in a divorce case refers to a situation in which one of the spouses either intentionally, purposefully, or voluntarily earns less income than what they used to earn. It is shocking to me that all of a sudden, all these people that used to have these professional jobs, they supposedly used to work long hours as the excuse why they couldn't come home and help their spouses with the kids or the pets or the chores of the house or cooking, no longer make that money or earn a career that is completely different and opposite to what they ever did. So the issue of underemployment of one of the spouses usually comes up when there is either a requirement for paying child support or a requirement for paying alimony. When it comes to alimony, the first step is determining if the person who needs alimony has a need for alimony and if the person who they want to pay alimony has the ability to pay it. So income is huge when it comes to alimony. Then when it comes to child support is governed by, at least in Florida, the child support guidelines. What that means is that Florida sets out a particular statute, which is 61.30. The statute lists 14 different classifications of what the courts will consider to be income. With the recent amendment of the alimony statute also refers to 61.30 when determining income for the person who is paying alimony. So there are 14 classifications. We're only going to go over a few. Some of the things that this particular statute mentions is obviously your salary, your bonuses, any type of rental income, any type of dividends or interest payments, any payments from either pensions, retirement accounts, or annuities, any social security payments, as well as anything that the court calls in-kind payments, which is reimbursed expenses or in-kind payments to the extent that they reduce living expenses. This is a big one because if, let's say, you get divorced and the spouse finds a new girlfriend, or his mommy and his daddy start paying for his car payment or her car payment, well, if that's a $500 a month car payment that someone else is paying on your behalf, the courts can impute that as income on you. So keep an eye on the in-kinds. So, why do people engage in underemployment? Well, the answer is obvious: to manipulate or reduce the amount of income that they earn so that they don't have to pay as much financial support to their families. An example may be a person who tries to work part-time or take a lower paying job, even though they have the skill set and experience to take a full-time or a higher paying job. They may also claim that the decision is made for personal reasons so that they can focus on child rearing duties, but a lot of times in reality it is a strategic move to reduce their financial obligations for child support and alimony. So it can become a big issue in a divorce case if someone really is underemployed. It takes a lot of effort to uncover this. So, what are some of the clues that a person is underemployed? Well, number one, if they have a history in one profession and then they get an entry-level job in a completely different profession, that might be a big clue. For instance, if the spouse is a pilot during the intact marriage and next thing you know, they become a cash register attendant at a McDonald's or Burger King or whatever, that is a big clue that they are not using their pilot skills to operate the cash register at McDonald's or Burger King. Also, the educational or work experiences. If their educational level doesn't match with what their jobs are. If the person has a degree in engineering and they decided to get a job as a bag boy or a bag girl or someone who bags their groceries, the education level doesn't match the skill set for the job that they're about to get in. Also, you got to look at the homemakers. Some of the homemakers sacrifice their time in the workforce to take care of their families. So when they go back into the workforce, you got to see if the homemakers are underemployed. This becomes more of an issue when you get closer to retirement, because there are some occupations in which you may be able to retire a little sooner. Think of like police department or fire department, and there are some that you can continue conceivably to keep working past your retirement age, like an attorney or like a teacher. So you got to look at the retirement ages as well. So what happens if you believe while you're going through a divorce that your spouse or soon-to-be ex-spouse is underemployed? Well, in order to address the issue of underemployment, you want the court to impute income to the underemployed spouse. If the underemployed spouse is messing around, being one of those attendants at a movie theater when they should be accountant, then you need to ask the court to impute the income of an accountant instead of a movie theater receptionist. It's important that you understand what imputation of income means. That means that the court assigns an earning capacity to the spouse who is underemployed based upon their qualifications, work history, job market conditions, rather than taking at face value their current income or their current work situation. Proving underemployment can be very challenging, as it requires proving evidence that the spouse is purposefully or intentionally suppressing their income. So, some of the things you can do. Number 1, employment history. Download or let your attorney or the court know what the previous employment history of your spouse was. So you can gather past jobs, past positions held, past letters of recommendation. This will help to establish a pattern of higher earnings and show a significant drop of income in their current job. Number 2, your spouse's education and professional qualifications. So document their education, training, and professional qualifications. If they have a license as a member of the bar or a doctor's license, that helps. Job market research is number 3. Conduct research on the latest market for your spouse's area of practice. Let's say that, again, use the example of a pilot, can get a listing of what the openings are for pilots and what the respective salaries are. It is important for you to get the salary range and compare it to the prevailing earning level in the community of these salary ranges. The current job opportunities. Look for job listings currently, today, meaning what is available today in your particular community. This can demonstrate that there are higher paying jobs in the same area and available even though your spouse is not pursuing this. One of the greatest assets that you can use is what's called the Department of Revenue and Labor Statistics. That you can actually isolate a particular job and how much in a particular community based on the zip code they are earning. You may have to get an expert witness, whether it be a vocational expert or a financial professional, to testify and provide an assessment and opinion about your spouse's earning capacity. These experts provide an opinion and testify in court as to a claim of underemployment. Up next is a lifestyle analysis. So if you see that your spouse's lifestyle and expenses seem to contradict what their current financial situation is, for instance, if they buy a new car, if they buy a new boat, if they start going on vacation, if they start going on trips, especially if they have a paramour, this is good stuff. Hand in hand with this is their social media and online presence. We did a big video on the pitfalls of social media. So monitor the spouse's social media and online activity to see if they're sharing information about their job prospects, or maybe they started a new job, or maybe they have a work event. Maybe they give you clues as to what their current job situation is. Now, remember, don't stalk people and don't act inappropriately. While you're gearing up for trial in this case, you are going to get subpoena all of the communication records of your former or soon-to-be former spouse, which includes emails, text message, and other communications where they may discuss their current or future job prospects. That is something that will help tremendously, as will financial records. Review all of the financial documents. I always love to look at the deposits. The deposits tell you sometimes what time the money comes in and from where, and sometimes there are deposits that need some explaining to do. Finally, if you're preparing for trial, you're probably going to conduct a deposition of either your spouse or their employer or their former employers or their friends or their circle of friends. So that may be the ultimate way of trying to ask them questions about underemployment and prove that they're not currently employed in a job that they should be or at the salary that they should be. Now, a couple words of caution. First, to all of my friends here in Miami-Dade County, remember that when a parent or party's underemployment is voluntary, the employment potential and probable earnings level of the person shall be determined, and this is the key, based upon their recent work history, occupational qualifications, and prevailing earnings level in the community. A lot of attorneys get banged up because they try to impute more income than what they have recently earned and what is earned in the community. So if they have been a worker at Starbucks, during the course of the marriage in Miami-Dade County, you cannot impute on them the salary of a lawyer or a doctor in California, because that's not what their recent work history shows, and it's not what the imputation of income is in their local community. Just like if you're handling a case in Miami-Dade County with the same Starbucks worker, maybe in California Starbucks workers get paid more. You can't use that data. You have to use the data from your local community. Remember, there are cases here in Miami-Dade County and in Florida on point that income may not be imputed at a level which the former spouse has never earned absent special circumstances. So tread carefully when you're imputing too high. Finally, remember that each jurisdiction across the states is different and each one has specific guidelines and laws related to underemployment. All right, so that's a wrap on all those spouses who may have to pay alimony and child support, who are mysteriously earning less money or who have now had a midlife crisis and are doing their dream job because they supposedly found themselves when they're really just trying to avoid paying what they're supposed to pay for their family. So if you know anyone that is dealing with these underemployed spouses, have them look us up at www.segarralawfirm.com. We have offices in Miami and Orlando, Florida, Salva Payon. And please do us a favor and like this video, subscribe to the Divorce Broadcast, and we will talk to you all soon.